Canada is known for its breathtaking landscapes and vibrant diversity, where people from all walks of life come together to form a unique national identity. But what truly holds us together, beyond our differences, is our strong and enduring system of law and order. This system is more than just a set of rules. It's a collective promise of safety, fairness, and predictability that allows us to live and work together in harmony. The Canadian justice system is designed to ensure our society functions peacefully, protecting everyone's rights and freedoms, no matter their background or beliefs. At its very core is the rule of law, meaning everyone, from government leaders to newcomers, is equally subject to the same laws and standards. No one is above the law, and everyone is held accountable for their actions, regardless of status or position. Decisions are made through established legal processes, not personal whims or unchecked authority, ensuring fairness and transparency. Our justice system stands as the guardian of our fundamental rights and freedoms, giving real meaning to concepts like freedom of speech, equality before the law, and the right to a fair trial. It provides a formal venue for individuals to stand up for their rights, resolve disputes, and be heard in a fair and impartial setting. This protection builds trust between citizens and the state, trust that is vital for a healthy democracy and a sense of belonging. The justice system reflects our shared values and adapts to serve a diverse, growing population, responding to new challenges as our society evolves. Its purpose is to uphold fairness, equality, and order for all Canadians, ensuring that everyone has the opportunity to thrive. While not perfect, the strength of our justice system depends on our understanding, engagement, and willingness to participate in its processes. Knowing how it works is key to being an engaged, informed citizen, empowering us all to contribute to a just and orderly society. To truly understand our justice system and how it works, we first need to explore the origins of our laws and the principles that shape them. Knowing where our laws come from helps us appreciate why they exist and how they guide our daily lives as Canadians. Canada's legal system is unique because it blends two major legal traditions, common law from Britain and civil law from France, reflecting our country's rich colonial history. Common law, which is used everywhere in Canada except Quebec, is based on judge-made decisions called precedents. These decisions build up over time, creating a body of law that guides future cases. In contrast, civil law, which is used in Quebec for private legal matters, relies on a comprehensive written civil code that sets out the rules in detail. This dual legal system is a direct reflection of our country's diverse roots, and it helps ensure that different traditions and perspectives are respected within our laws. In addition to these traditions, we have statute laws, rules that are written and passed by our elected governments at both the federal and provincial levels. Statutes can cover a wide range of issues, from criminal acts to environmental protection, and they have the power to override common law when there's a conflict. But above all these laws stands the Constitution of Canada, which is the supreme law of the land and the foundation of our legal system. The Constitution divides powers between the federal and provincial governments, and it also includes the Charter of Rights and Freedoms, which sets out our most fundamental rights. The Charter guarantees essential rights and freedoms, such as freedom of expression, freedom of religion, and the right to vote, ensuring that all Canadians are treated fairly and equally. All other laws in Canada must conform to the Constitution, which acts as a check on government power and protects our rights. This legal framework ensures that our laws reflect democratic values, promote justice, and safeguard the liberties of everyone who calls Canada home. Ultimately, the Constitution and the Charter are the ultimate safeguards for our rights, freedoms, and the rule of law in Canada. The police are the most visible part of the justice system, keeping communities safe and maintaining order. They enforce laws, prevent crime, and respond to emergencies, often being the first to help in a crisis. Police also engage in community outreach and education, working proactively to solve problems. Canada's policing has 3 levels: federal, provincial, and municipal. The RCMP enforces federal laws and serves as provincial or local police in many areas. Ontario and Quebec have their own provincial police, the OPP and Sûreté du Québec. Municipal police serve large cities, handling local law enforcement and community safety. Regardless of the uniform, all police share the mission to serve and protect. Their work is a cornerstone of public safety and trust. They help ensure our communities thrive. When disputes or crimes arise, They're resolved in Canada's courts, structured like a pyramid. At the base are provincial and territorial courts, handling most criminal, family, and small claims cases. Above them are superior courts, dealing with serious criminal and civil matters, and reviewing lower court decisions. Federal courts handle issues like immigration, lawsuits against the government, and intellectual property. At the top is the Supreme Court of Canada, the final court of appeal for the nation. The Supreme Court hears only cases of national importance or crucial legal questions. Its decisions are final and shape Canadian law and society. Judges are appointed to ensure expertise and diverse representation. This structure ensures fairness and consistency across the country. Understanding the courts helps demystify the legal process. In a Canadian courtroom, several key players work together to ensure that justice is served fairly and transparently. Each person in the courtroom has a unique and vital role, contributing to the integrity of the legal process. The judge acts as an impartial referee, ensuring fairness and applying the law. Judges oversee the proceedings, rule on legal matters, and provide instructions to the jury, guiding the trial with authority and neutrality. The Crown Prosecutor represents the government, presenting evidence against the accused and seeking justice, not just convictions. Their responsibility is to present the facts honestly and to pursue the truth, rather than simply aiming for a guilty verdict. The defense lawyer protects the accused's rights, challenges the Crown's case, and ensures a fair trial. They advocate for their client, scrutinize the evidence, and make sure the accused receives a proper defense. Every accused person has the right to legal representation, ensuring even the vulnerable have a voice. This right is fundamental, allowing everyone, regardless of background or resources, to participate fully in their own defense. In serious cases, a jury of 12 citizens decides guilt or innocence after hearing all the evidence. Jurors are selected from the community and bring diverse perspectives to the process, reflecting the values of society. The jury acts as the trier of fact, the judge is the trier of law. This division of responsibility ensures that both legal expertise and community judgment are part of the decision-making process. All jurors must agree on the verdict, reflecting community judgment. Their unanimous decision is a powerful safeguard, ensuring that the outcome is fair and just. This adversarial system protects against wrongful convictions and upholds fairness. By allowing both sides to present their case, the system encourages thorough examination of the evidence. Each role is essential for justice to function. The collaboration and checks between these players help maintain the integrity of the process. The process is designed to balance the power of the state and the rights of individuals. This balance is at the heart of the Canadian legal system. It's a system built on accountability and trust, where every participant is held to high ethical standards. Together, these players make justice possible, ensuring that the legal process serves everyone in society. The Canadian justice system is guided by core values that protect fairness and dignity. The presumption of innocence means everyone is innocent until proven guilty. The Crown must prove guilt beyond a reasonable doubt. The accused doesn't have to prove innocence. Due process guarantees fair treatment, from arrest to trial, including the right to a lawyer and a timely trial. The rule of law ensures everyone is equal before the law, with no one above it. Judicial independence allows judges to make impartial decisions free from outside influence. Equality before the law, enshrined in the Charter, means everyone is treated with respect, regardless of background. These principles are ongoing goals, shaping a justice system that strives for fairness. They reflect Canada's commitment to justice for all. Justice doesn't end with a verdict. Corrections play a crucial role. The correctional system both enforces sentences and focuses on rehabilitation, helping offenders become law-abiding citizens. Sentences under 2 years are served in provincial jails, longer ones in federal penitentiaries. Programs in these institutions support education, job skills, and personal growth for reintegration. The justice system also relies on citizens, as victims, witnesses, and jurors. Jury duty is a civic responsibility, putting justice in the hands of the community. Legal aid ensures access to justice for those who can't afford a lawyer. The system evolves to reflect Canadian values, addressing issues like overrepresentation of Indigenous and Black Canadians. Restorative justice initiatives focus on healing and community. The justice system is a living institution, always adapting. Its strength comes from our participation and commitment to fairness. The journey toward a more just society never ends. We all have a role in shaping it.